Welcome to Talk Trials, your premier Supreme Court argument and opinion analysis podcast.
It is good to be back.
You know, we usually think of the Supreme Court dealing with the big, flashy, headline-grabbing constitutional rights.
Absolutely. Free speech, gun rights, that sort of thing.
The stuff that makes for good TV dramas.
Yeah.
But the real machinery of the American government, I mean, the gears that actually grind and determine how our lives are lived, that stuff usually gets hidden in the basement.
It does, and today we are definitely going down to the basement.
And it is noisy down there.
Okay.
We are looking at a case that, on paper, seems almost designed to be boring. It's Environmental Protection Agency v. Calumet Shreveport Refining, LLC.
A mouthful.
A total mouthful.
Wow.
And it's technically about venue. But saying this case is about venue is like saying Game of Thrones is technically about chairs.
That's a fair comparison, because this case is really about a turf war. It's about who gets to control the massive administrative state. Is it the local judges who live near the people being regulated?
Or is it the specialized judges in Washington, D.C. who, live and breathe this stuff and live near the regulators?
It's a huge question. The decision came down on June 18th, 2025. And while the name of the case involves oil refineries, the real battle here is between the home court advantage of these regional courts versus the, let's call it, centralized power of the D.C. Circuit.
And the Supreme Court has finally stepped in to settle a circuit split that has been brewing for years over this very issue in the Renewable Fuel Program.
It was getting messy. You had different courts saying different things.
So let's set the stage for you. On one side, we have the EPA, the Environmental Protection Agency. On the other, we have a group of small oil refineries. And the core legal question, when you boil it all down, is this.
When the EPA denies a hardship exemption for one of these small refineries, where does the lawsuit go?
Right. Does it go to the regional circuit court, like the 5th Circuit in New Orleans or the 10th Circuit in Denver, where these refineries physically sit?
Or does it get funneled exclusively into the U.S. Court of Appeals for the D.C. Circuit?
And to put it in perspective, the refineries fought tooth and nail to keep these cases in their regional circuits. They wanted local judges.
And the EPA fought just as hard to consolidate everything in D.C.
So what did the court decide?
Well, on June 18, 2025, we got our answer. The Supreme Court held that challenges to these small refinery exemption denials must be heard in the D.C. Circuit.
A big win for the EPA on the venue question.
A huge win. And it was a decisive 7-2 decision. Justice Thomas delivered the opinion of the court.
And who was with him?
He was joined by a really interesting coalition, Justices Alito, Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson.
Wow. That is quite the lineup. You have the staunchest conservatives and the entire liberal bloc joining forces.
It's a mix that always makes you look closer.
It really does. When Sotomayor and Thomas agree on a statutory interpretation case, something really interesting is happening with the text.
And then on the other side, in dissent, we had Justice Gorsuch, and he was joined by Chief Justice Roberts.
Fascinating in itself, and we're absolutely going to get into what that alignment tells us about textualism versus, I guess, administrative pragmatism later on.
Right. But for now, the high-level rationale was this. The court found that while the EPA's actions were technically locally or regionally applicable...
So step one, they're local.
They're local, but, and this is the huge but, they fell into a specific statutory exception because they were, and this is the key phrase, based on a determination of nationwide scope or effect.
So it's a two-step dance. The action itself is local, but the reason behind the action is national.
And the court found that the EPA's reasoning for denying all these petitions was so broad, so rooted in a national policy, that it triggered a venue transfer to Washington.
Okay, let's unpack this. Because to really understand why everyone is fighting so hard over where to sue, we first have to understand what they're actually fighting about. We need to talk about the Renewable Fuel Program.
Our mission today is to unpack the Supreme Court's interpretation of this tiny little provision in the Clean Air Act. But you're right. To do that, we have to understand the underlying regulatory headache that caused this whole lawsuit.
The Renewable Fuel Standard, or RFS.
The RFS itself.
Right. So let's get into the what, the regulatory context. Imagine for a moment that you're running a small refinery in, say, Shreveport, Louisiana. Your job is to take crude oil and turn it into gasoline.
Seems simple enough.
It seems simple enough, but then the government steps in and says, not so fast.
Right. Congress created the RFS, and the goal was to increase the amount of renewable fuel, think ethanol, mostly in the nation's supply.
And the stated goals are what? Reduce reliance on foreign oil, cut greenhouse gas emissions?
All of the above. So every year, the EPA sets what they call volume mandates. They basically say, this year, the U.S. as a whole needs to use X billion gallons of ethanol.
Okay, so there's this giant national number, a quota.
A national quota. But that obligation doesn't just float in the ether. It has to land on someone.
It lands on the refineries.
Correct. The EPA takes that national number and divides it up proportionally based on how much gasoline and diesel each refinery produces. So if your refinery in Shreveport produces, say, 1% of the nation's gas,
then I'm on the hook for blending 1% of the nation's ethanol.
You've got it. That's your obligation.
Now, this brings us to the currency of this whole system, which is maybe the most confusing part for outsiders. RINs. Renewable identification numbers.
Oh, RINs, they're like a whole separate universe. Think of RINs as golden tickets, or maybe more accurately, as proof of compliance.
A receipt.
A digital receipt. When a gallon of ethanol is produced and then blended into transportation fuel, a RIN is generated and attached to it. It's a 38-digit serial number.
So if I'm a huge company, let's say I'm Exxon or Shell, and I have these massive blending terminals, this is relatively easy for me.
For the big integrated companies, it is. They buy the ethanol, they have the infrastructure, they mix it into their gasoline at their own terminals, they peel off that digital RIN sticker, and they put it in their compliance account.
And at the end of the year, I just hand the EPA a big digital file of these RINs and say, look, I did my job, we're good.
Exactly. For them, it's a cost of doing business, but it's manageable. They control the whole process.
But what if I'm the little guy? What if I'm that refinery in Shreveport? I might be an old refinery. I just have a distillation tower. I take crude in, I pump gasoline out into a pipeline that someone else owns.
You don't own the trucks. You don't own the gas stations.
Right. I physically cannot blend ethanol into my gasoline before I sell it. I don't have the equipment.
And that is what the industry calls the blending wall. If you're a small, independent refinery without your own blending infrastructure, you're in a serious bind.
Because I still have the legal obligation.
Yeah.
The EPA still says I owe them those RINs.
The obligation doesn't go away, but you can't generate the RINs yourself because you aren't actually doing the blending.
So what am I supposed to do? Go to jail? Shut down?
You have to go to the open market. There's a whole market for RINs. You have to buy these RINs from other companies, sometimes your direct competitors who have extra ones.
So I'm not buying fuel, I'm just buying the credit, the piece of paper.
You are buying a piece of paper, a digital credit.
Yeah.
And this is where the economics can get absolutely brutal for these small guys.
Why is that?
Because the price of RINs is not stable. It is a commodity. It fluctuates wildly based on, corn harvests in Iowa, based on EPA announcements, based on pure market speculation.
So one year, a RIN might cost a few cents, and the next year?
The next year, it might be $2. And we've seen those kinds of swings.
And if my refinery is operating on razor-thin margins, maybe I only make a few cents of profit on each gallon of gas I sell, having to suddenly go out and buy millions of dollars worth of these RINs.
It can wipe out your entire year's profit. It can, and in some cases has, threatened to bankrupt these companies.
Which is why Congress, and to their credit, they seem to have realized this might be a problem, created a safety valve.
They did. It's called the Small Refinery Exemption, or SRE.
Okay, so what are the rules for that?
Under the Clean Air Act, a small refinery, and that's defined as one processing under 75,000 barrels of crude oil per day, can petition the EPA for an exemption from its annual obligation.
And what do they have to prove?
They have to show that complying with the mandate will cause them disproportionate economic hardship.
Disproportionate economic hardship. That sounds incredibly subjective.
It is. I mean, what is hardship? Is it losing money? Is it making less money than you hope to make? It's squishy.
So how was it supposed to work?
Well, the statute says the EPA, in consultation with the Department of Energy, has to look at the specific economic factors affecting that specific refinery.
So it's supposed to be a case-by-case analysis.
Intensely fact-specific. They're supposed to look at your cash flow, your debt, your access to capital, the specific market conditions in your region, a truly individual assessment.
Now, before we go further, we have to mention a previous Supreme Court case, HollyFrontier. We don't need to get deep into the weeds on it, but it's important background.
It really is. Basically, for a while, the EPA took the position that if you didn't get an exemption one year, you couldn't get one the next. You had to have a continuous chain.
And the Supreme Court in HollyFrontier said, no, that's not what the statute says. You can apply for an extension of an exemption whenever you need to.
And that ruling opened the floodgates. Suddenly, all these small refineries realized they could apply for exemptions even if they had missed a few years.
So the EPA, which was already dealing with a lot of these petitions, was suddenly sitting on a massive backlog backlog.
A mountain of paperwork from refineries all over the country.
Okay, so picture this. It's 2022. The EPA has this enormous stack of petitions. Dozens of small refineries are all begging for relief, saying the price of RNs is absolutely killing us.
And the EPA, rather than hiring an army of accountants to go through every single refinery's books one by one,
They decided to clear the deck.
they went for the select all, delete approach. In April and July of 2022, the EPA issued 2 big omnibus notices.
Omnibus? What do you mean?
Instead of issuing a separate, detailed, individualized decision for each of the 100-plus refineries, they denied 105 pending petitions in 2 giant batches.
They denied them all. Just a blanket no.
Effectively, yes. It was a presumptive denial of every single one. And they did it based on 2 new pillars of denial.
And this is crucial, right? Because this reasoning is what ends up triggering the whole venue fight later on.
This is the entire ballgame.
Okay, let's break those pillars down, because this is really where the EPA changes the game. What was their first big argument?
Pillar number 1 was a brand new statutory interpretation. The EPA essentially redefined disproportionate economic hardship.
How so?
They said, from this point forward, hardship only counts if it is caused by your compliance with the Renewable Fuel Program.
Wait, I'm confused. Isn't the hardship having to buy the RINs? That is the compliance.
But the EPA's point was, if you're losing money because you have bad management, or because there was a hurricane that shut you down, or just because the local economy is terrible, that doesn't count.
So they wanted to isolate the RIN costs from all other business problems.
Exactly. They said, we're not here to bail out a badly run company just because it happens to be small.
Okay, I guess I can sort of see the logic in that, even if it's harsh. But what was the second pillar?
This is the really controversial one. Pillar number 2 is what's known as the RIN pass-through theory.
That sounds like something straight out of an economics 101 textbook that doesn't really work in the real world.
It is a pure economic theory. The EPA argued that, generally speaking, refineries do not actually bear the cost of these RIN credits.
How is that possible? They have to buy them. It's a line item on their expenses.
The EPA argued that in a perfectly competitive market, the cost of the RIN is simply built into the market price of the gasoline that the refinery sells.
So they're saying that when my little refinery in Shreveport sells its gasoline into the pipeline, I just bump up the price by a few cents to cover the cost of the RIN I had to buy.
That's the theory. The theory is that the ultimate consumer at the pump pays the cost. The refinery just acts as a middleman. It passes through the cost.
So the EPA's conclusion is what?
Therefore, according to the EPA, the refinery cannot possibly suffer economic hardship from the cost of RINs because they are getting fully reimbursed by the market every time they sell a gallon of gas.
But hold on a second. If I'm that small refinery in Shreveport and I'm competing against a massive Exxon refinery down the road,
right?
Exxon has lower costs because they blend their own fuel and generate their own RNs. If I try to raise my price to cover my RIN purchase cost, won't Exxon just undercut me and I won't sell any fuel?
That is precisely what the small refineries argued. They said, this theory assumes a perfect market that doesn't exist. We are price takers, not price makers. We can't just unilaterally raise our prices.
But the EPA didn't buy that argument.
No. The EPA applied this pass-through theory universally as a nationwide economic principle. They said, because markets generally work this way, we are going to presume that you recovered your costs.
So let's just look at the trap they set. Pillar 1, hardship must be caused by compliance.
Right.
Pillar 2, compliance costs, i.e. RINs, are passed through to consumers. So they don't actually cause hardship for the refinery.
Which means?
Result, no refinery can ever qualify for an exemption.
It's a perfect catch-22. The EPA used these 2 nationwide determinations, a new legal interpretation and a new economic theory, to create a blanket presumption that all 105 petitions should be denied.
And what about the individual facts? Did they even look at the books?
They claimed they did a confirmatory review of the individual facts for each refinery, but, and this won't surprise you, they found that none of the individual facts were powerful enough to overcome their new national presumptions.
So this is the Davids versus Goliath moment. You have 105 small businesses across the country. They feel like the government just changed all the rules in the middle of the game using a theoretical spreadsheet.
And naturally, they sue.
But here's the key. They don't all sue in Washington, D.C.
No, they sue in their backyards. They go to the Fifth Circuit for Louisiana and Texas, the Third Circuit for Pennsylvania, the 10th Circuit for Wyoming and Utah. They want local judges.
Judges who might, drive past the refineries on the way to work and understand the local economy. They want those judges to look at their specific hardship.
And the EPA panics a little bit. They do not want to fight 105 separate legal battles in 10 different courts all over the country.
They want one battle on their home turf in one court.
And that brings us to the rules of the road, the venue statute.
This is where we get really deep into the procedural weeds. It's Clean Air Act, Section 7607B1.
And it sets up what the court calls a tripartite system, which is just a fancy lawyer way of saying there are 3 buckets your lawsuit can fall into.
3 buckets for where to file. Let's walk through them nice and slow. Bucket number 1.
Bucket 1 is for nationally applicable actions. If the EPA does something that applies to the whole country, like setting the national ambient air quality standards for ozone or changing the exhaust standards for all new cars.
Something that affects everyone everywhere.
Then you must file your lawsuit in the D.C. Circuit. It has exclusive jurisdiction.
And why D.C.? Why does that one court get so much power over these national rules?
For uniformity. You can't have the Fifth Circuit saying the air quality standard for the country is X and the Ninth Circuit saying it's Y.
Right.
For big national rules, you need one court to give one answer so that industry knows what the rules are.
That makes sense. If I'm Ford Motor Company, I don't want to build a different car for Texas and a different one for California. Okay, so that's bucket 1. What's bucket number 2?
Bucket 2 is the default. It's for locally or regionally applicable actions. If the EPA approves a state's air quality plan just for Texas, or issues a permit for a single factory in Ohio, that's a local action.
And those cases go where?
They go to the regional circuits. The case about the Texas plan goes to the Fifth Circuit. The case about the Ohio factory goes to the Sixth Circuit.
This is the default for local stuff.
Yeah.
But then there's bucket number 3. The exception, the trapdoor.
This is the tricky one. This is what the whole case is about. The statute says that even if an action is locally or regionally applicable, it must go to the D.C. Circuit. IF, 2 things happen.
Okay, what are they?
First, the action has to be based on a determination of nationwide scope or effect. And second, the EPA has to find that and publish that finding in the Federal Register.
So let me see if I get this. If a decision that only affects one guy in one place is actually based on a big national policy.
It gets sucked into the D.C. Circuit vortex.
Exactly. And that is where the conflict in Calumet Shreveport just exploded. The refineries argued, look, we're individual companies. We filed individual petitions. The EPA's denial letter affects only us here in Shreveport or over in Wyoming. This is classic bucket 2 local.
And the Fifth Circuit, where Calumet Shreveport filed its case, agreed with them, right?
The Fifth Circuit did. They kept the case. They said, look, just because the EPA used some national reasoning in its letter doesn't change the fact that the actual legal effect of the denial is purely local. They refused to transfer the case to D.C.
But other circuits were going the other way.
Right. And the EPA appealed to the Supreme Court. They argued that if the Fifth Circuit keeps this case, you could have absolute chaos. You could have the Fifth Circuit rejecting the pass-through theory and ordering exemptions, while the 10th Circuit accepts it and denies them.
You'd have 2 different renewable fuel programs running in different parts of the country.
So the Supreme Court had to step in and resolve this. And Justice Thomas writes the opinion. And it is a fascinating piece of legal reasoning because it looks like a win for the little guy at first.
But then it completely pulls the rug out.
Let's walk through the majority's logic. Justice Thomas takes a very, very textualist approach. He breaks it down into 2 clean steps. Step 1, we have to identify the action. What is the action the EPA took?
This seems simple, but it's actually a huge point of contention. The EPA tried to argue that by bundling 105 denials into one big document, they had created a single nationally applicable action.
They tried to say, we use the reply all button, therefore our email is a national policy.
That's basically the argument. They said, look, we denied people in 18 different states across multiple circuits. That's national in scope.
But the court completely rejected that.
Unanimously, in fact. Justice Thomas looked directly at the statute. The Clean Air Act says a small refinery may petition for an extension. It's singular. The EPA must act on any petition. Also singular.
So the fundamental unit of analysis isn't the EPA's memo, it's the individual petition from the refinery.
Correct. The court held that the action at issue is the denial of a single petition. And a denial of a single petition for a single refinery in Shreveport is, by definition, locally applicable. It applies to one entity in one place.
So the EPA loses big on bucket one. These are not nationally applicable actions just because the EPA decided to staple them all together.
It's a really important holding. The court is saying an agency can't just package its way out of regional review. You can't bundle a bunch of local actions and call them national.
Right. If the opinion had stopped right there, the refineries would have been popping the champagne.
They would have. But then we get to step 2, the exception. Okay, so we've established the action is local. The next question is this local action based on a determination of nationwide scope or effect?
And this is where the textualism gets really granular. The court had to interpret the simple phrase, based on. What does based on actually mean? Does it mean partly caused by? Does it mean influenced by?
The court adopted what it called a core or primary driver test. Justice Thomas wrote that for this exception to apply, the nationwide determination can't just be a reason. It has to be the primary driver or the sine qua non of the decision.
Sine qua non, the classic Latin, without which not.
Exactly. The court is asking, was the national policy the main reason you did this? If we took away that national policy, would the decision still stand?
And when you look at the EPA's denial letters, the answer to that seems pretty obvious.
It was inescapable. The court looked at the record and said, the EPA's denial wasn't really based on Calumet Shreveport specific profit margins or its local labor costs.
It was based on the pass-through theory and the new statutory interpretation.
The 2 pillars we talked about, exactly. And those 2 pillars apply to everyone, everywhere. They are classic determinations of nationwide scope.
So the court found the EPA used those pillars to reach a presumptive denial.
A presumptive denial. And the individual facts of the refinery, the court called them peripheral. They were just used to confirm what the national theory had already decided. The outcome was baked in from the start because of the national policy.
So let me get this straight. The court says, yes, this is a local action involving a local business.
Right.
But then they say, however, the reason the EPA crushed you is a national reason. Because the reason is national, you have to go to the national court to challenge it.
That is a perfect summary. The court also clarified that this is a de novo review for the courts of appeals.
What does that mean?
It means courts don't just have to take the EPA's word for it when it publishes that finding. The judges themselves must look at the agency's decision and ask, what is the core reason here? What is the primary driver? In this case, the core reason was clearly the nationwide policy against granting these exemptions.
Now, the refineries and the dissent tried to argue against this. They had a few counter-arguments.
They did. They argued that a determination has to be a specific term of art in the statute, not as just any old reason. The court said, no, it just means the reason.
They also argued that because the EPA considered local facts, the decision wasn't based solely on national stuff.
And the court shot that down too. Justice Thomas was very clear. He said, based on doesn't mean based solely on, it just means based primarily on. If the national theory does 90% of the analytical work and the local facts only do 10%, that's enough. You go to D.C.
He really does feel like a Trojan horse.
Mm-hmm.
The EPA sent a local-looking letter, but inside the envelope was a full-blown national regulation.
That is a great way to put it. And because the contents of the letter were national, the venue becomes national.
Which, of course, leads us to the dissent. Justice Gorsuch, joined by Chief Justice Roberts. And let me tell you, Gorsuch was, well, he was not impressed with this primary driver test.
Not at all. Justice Gorsuch loves clarity. He hates squishy multi-factor tests where judges have to weigh percentages and guess at an agency's motives.
He wants bright line rules.
He wants rules that ordinary people, and maybe more importantly, ordinary lawyers, can follow without having to litigate the question of venue for 3 years before you even get to the merits. He used a fantastic analogy. Traffic rules.
Tell litigants where to go.
Exactly. He argues that venue statutes should be simple. Red light, you stop here. Green light, you go there. Local action, local court. National action, national court. He doesn't want the venue to depend on a literary analysis of the EPA's 200-page rejection letter.
He thinks the majority's test is just too messy.
He thinks it's a procedural nightmare. He argues that this new core primary driver test forces courts to act like literary critics. They have to read hundreds, maybe thousands of pages of the administrative record and try to weigh which reasons were core and which were peripheral.
Was the pass-through theory 60% of the reason? Or was it only 40%?
Exactly. And Gorsuch asks, how do you even do that? How do you weigh a legal interpretation against a factual finding? It's comparing apples to oranges. He argues this will lead to endless expensive litigation just to decide where to litigate.
He also brings up the classic slippery slope argument. He talks about SIP's state implementation plans.
This is a really powerful part of his dissent. The EPA has to review air quality plans, or SOPs, for every state. Gorsuch poses a hypothetical.
What if the EPA uses a common spreadsheet, a common methodology, to deny 21 different state plans all at once?
Does that mean a dispute that is fundamentally about Utah's air quality plan involving Utah's mountains and Utah's industries suddenly has to be heard in D.C. just because the EPA used the same math for Utah as it did for Delaware?
Under the majority's rule, if that methodology is found to be the primary driver, then yes, Utah loses its right to be heard in its home court, the 10th Circuit.
Gorsuch fundamentally disagrees with the majority's focus. He argues that the statute actually focuses on the specific finding required by the substantive law, not the reasoning the agency uses.
So he's saying, I don't care how the EPA made the decision. The law asked for a local decision. Therefore, it is a local dispute.
Precisely. He's saying stop looking at the EPA's excuse and look at what the law actually asked them to do. The law asked the EPA to determine if a small refinery suffers hardship. That is a local inquiry.
So in his view, if the EPA decides to use a national standard to do that local checkup, that's just an administrative choice, but it shouldn't be allowed to strip the regional courts of their rightful jurisdiction.
It is a really compelling argument for simplicity and for respecting the traditional role of regional courts, but he lost, and he lost big, 7-2.
You did. The majority, it seems, prioritized the practical reality of the modern administrative state over the simplicity of the rule.
I think that's right. The reality is that agencies do make national policy through these mass adjudications, and if EPA is effectively making a national rule that says no more exemptions for anyone, the majority thinks that rule should be judged by the D.C. Circuit, which specializes in reviewing national rules.
So what does this all mean? Let's zoom out to the legal context and significance. Why should a listener who doesn't own an oil refinery, why should Bob the accountant or Sarah the teacher care about this case?
It matters because of the powerful trend toward centralization. This decision very clearly funnels more administrative law cases challenging the actions of federal agencies to the D.C. Circuit.
And the D.C. Circuit is already often called the second most important court in the land, precisely because of its immense control over federal regulations.
And this decision reinforces and probably expands that power. Now, there are pros and cons to this.
Okay, what's the pro?
The pro is obvious. Uniformity. You don't have conflicting rules in different parts of the country for a national program like the Renewable Fuel Standard. If the EPA's pass-through theory is valid, it should be valid everywhere. If it's arbitrary and capricious, it should be struck down everywhere. One answer for one national program.
That makes a lot of sense. But what are the cons?
The biggest con is the loss of what lawyers call percolation. The Supreme Court often benefits from seeing how different regional circuits handle a difficult legal problem before they step in.
So if the Fifth Circuit says one thing and the 10th Circuit says another, the Supreme Court gets to look at both well-reasoned arguments and pick the best one.
Exactly. If everything goes straight to D.C., you lose that diversity of judicial thought. You only get one take on it before it gets to the Supreme Court.
And you also lose the local context, don't you? A judge in the Fifth Circuit who sits in New Orleans or Houston might just understand the economics of the oil and gas industry in a visceral, on-the-ground way that a judge in D.C. might not.
Or a judge in the 10th Circuit might understand the specific geographical challenges of a refinery in the Rocky Mountains. By moving everything to D.C., you abstract the issue. It becomes purely about administrative procedure and statutory text, and it gets detached from the real-world reality.
There is also the strategic angle here. Agency strategy. If I am the EPA administrator, and I know the conservative Fifth Circuit is probably going to be hostile to my new regulation,
right?
Does this decision just give me a roadmap? Do I just make sure to include a nationally applicable preamble in all my decisions now to guarantee I get sued in the more agency-friendly D.C. Circuit?
That is the big risk that Justice Gorsuch warned about. Now, the majority tried to put a break on that. They said bundling a bunch of local actions alone isn't enough. But they did say that if your reasoning is primarily national, you get D.C. venue. So yes, this absolutely incentivizes agencies to explicitly rely on national policies, national data sets, and broad legal interpretations in their local decisions. It effectively gives the agency a playbook to select its own forum.
They can write their own ticket to D.C.
To an extent, yes, as long as they're honest about their reasoning. Remember, the court said it's a de novo review. The judges will check your work. But if an agency truly does base its decision on a national policy, they get the home field advantage of the D.C. Circuit.
It creates this fascinating dynamic where the way you write the decision literally determines who gets to judge it.
Which is exactly the manipulating venue problem that Gorsuch was so worried about in his dissent.
Okay, we have analyzed the majority opinion, we have analyzed the dissent, and we have looked at the broader implications. Now it is time for us to take a seat on the bench.
It is time for the 10th chair.
Sitting as the 10th chair, Talk Trials now offers its independent reasoned judgment on EPA v. Calumet Shreveport. And we must always remember our analysis, including the judgment offered here on the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice and does not represent the actual holding or views of the Supreme Court.
With that disclaimer in place, this is a tough one today.
It really is. I find myself genuinely torn. On one hand, Gorsuch's traffic rules argument really appeals to my sense of fairness and simplicity. If I'm a local business, it feels like I should get a local judge. Why should I have to hire a D.C. lawyer at $2,000 an hour just to fight a regulatory ticket?
I completely agree with the fairness angle, but I also worry about the chaos. If we rule for the refineries and the Fifth Circuit strikes down the pass-through theory, but the D.C. Circuit in another case upholds it, what does the EPA do? Do they have to use one set of economic principles for Texas and Louisiana and a completely different set for Maryland and Virginia? That seems unworkable for a national program.
But isn't that just how our federal system works sometimes? We have circuit splits all the time on major issues. Eventually, the Supreme Court steps in and resolves it. Gorsuch would just say, let it percolate.
True, that's the traditional view. But I think administrative law is different. It relies on consistency and predictability. If the underlying math of a huge national program is in question, you want that settled for everyone, and you want it settled quickly.
Okay, but let's look at the majorities test, this primary driver test. Isn't that just a recipe for endless litigation? Every single time an agency issues a decision based on a mix of local and national factors, the lawyers are going to fight for 2 years about whether the core reason was 51% national or 49% national. It feels like we are creating more work for lawyers, not solving problems.
That is a very valid critique. The primary driver test is dangerously subjective. It requires the judge to get inside the agency's head and weigh imponderables. It's not a clear rule.
So do we have a better way? If we are the 10th chair, how do we solve this puzzle? We want the efficiency and uniformity of D.C. for truly national issues, but we want the clarity and simplicity of Gorsuch's rules. Is there a middle ground?
I think there is. I think we affirm the outcome. We agree that venue in this specific case belongs in the D.C. Circuit, but we would modify the reasoning to create a much stricter, clearer test for the future.
Okay, I'm intrigued. Let's hear the 10th chair's new doctrine.
We would propose what we'll call a rebuttable presumption or explicit reliance test.
Break that down for us. What does that mean?
Instead of asking the judge to engage in a subjective weighing of the core or primary driver, we would look for a clear, bright-line trigger. The rule would be this. If an agency, in its decision-making process, utilizes an explicit rebuttable presumption that is derived from a nationwide policy to adjudicate a local petition, venue automatically defaults to the D.C. Circuit.
Okay, explain how that would work in this specific case with the refineries.
In this case, the EPA explicitly said, because of our nationwide pass-through theory, we presume that you are not suffering economic hardship. The burden is now on you, the refinery, to prove us wrong.
Okay, so they use a national theory to set the default answer to no.
Exactly. The moment the agency formally sets a nationwide presumption and shifts the burden of proof based on it, the core legal dispute is no longer about the refinery's local facts. The core dispute is now about whether the presumption itself is legal and valid.
Is the pass-through theory good economics and good law? That becomes the real fight.
Correct. And the validity of the pass-through theory is a question of nationwide scope. It applies to every refinery in the country. Therefore, the fight over that theory belongs in the D.C. Circuit.
How does this test differ from what the majority actually did?
It avoids the messy weighing game. Under our test, it doesn't matter if the EPA spent 50 pages discussing local facts and only 5 pages on the presumption. We just ask one question. Did the agency use a national presumption to stack the deck? Yes or no? If the answer is yes, the case goes to D.C. It's a clear trigger.
I see. So that satisfies the majority's desire for efficiency by sending the big national questions to the D.C. Circuit.
But it also gives Justice Gorsuch the clear, simple, bright-line traffic rule that he wants. There's no weighing. There's no guessing.
And it also protects regional venue for cases that are truly local. If the EPA had just looked at Calumet's books and said, sorry, your numbers just don't show hardship, without relying on any national presumption,
that case would stay in the Fifth Circuit under our rule, but because they applied that national filter first, they triggered the national venue.
It also stops the agency from being cute about it. If they want to use the big national hammer of a presumption, they have to be willing to answer for it in the national court.
And it protects the little guy, in a way. If the dispute is truly just about, hey, you got my revenue numbers wrong, that stays local. But if the dispute is, hey, your entire economic theory for this program is junk science, that goes to the administrative law experts in D.C.
I like it. A sensible, clear middle ground from the 10th chair. It balances the David versus Goliath fairness with the process versus pragmatism reality of the administrative state.
We try our best from our imaginary seat on the bench.
So, to recap for everyone, the Supreme Court ruled 7-2 that the EPA's denial of these small refinery exemptions belongs in the D.C. Circuit.
And the key takeaway: even if an agency action is technically local, it gets sent to D.C. if the core of the agency's reasoning is a determination with nationwide scope or effect.
This settles the immediate fight for these specific refineries, but the bigger war over venue in the administrative state is it's far from over.
As long as federal agencies have the power to regulate nationally, the battle over where those regulations get challenged is going to continue.
I want to leave you with a final thought to chew on. Justice Gorsuch warned in his dissent that venue rules should be simple traffic laws. Red light, green light, simple directions. But we live in an administrative state where a single spreadsheet model developed in a Washington, D.C. office can decide the economic fate of industries across all 50 states.
It raises a really profound question. Can the traffic laws ever really be simple when the traffic itself is this complex?
Or are we just destined for a world where you sue becomes just as important and just as heavily litigated as what you're suing over?
A question for the next term, perhaps.
Thanks for listening to Talk Trials.
Until next time.